we are back. We've crossed over the Atlantic and now we're in Latin America. I want to be able to introduce my friends from Latin America. Tatiana is going to be moderating a panel on data privacy and cybersecurity. She's from Brazil. She's coming in from Sao Paulo. We have I'm looking at the stages. Not Marcelo, I keep saying Mariano. Apologize. Mariano from Buenos Aires, Paulina coming from Chile, and of course Sofia in Uruguay. I believe you're in Montevideo, right? Is that correct? Okay, wonderful. So this is going to be a great panel conversation. We want you all to get engaged. We love that participation. Make it interactive so that it's not just a one-way conversation. With that, I'm going to pass it on to Tatiana. Enjoy, and it's your stage. Thank you.
Thank you. Thank you. It's a pleasure. And thank you for the invitation and the opportunity to put this panel together. And actually, I'm from Rio, but I switched between Rio and São Paulo City. Just a small correction. I'm partner from Demarest, the Brazilian law firm, and I'm very involved with privacy. As you can see, we have a lot of things going on in Brazil and privacy. I'll be pleased to share a little bit with you. But before that, I would like to introduce my other speakers and colleagues who I'm very pleased to invite for this panel. And I will start with Mariano from Argentina. Mariano, can you please introduce yourself?
Yes, thank you, Tatiana. Hi, everyone. Yeah, my name is Mariano Peruzzotti. I'm a senior attorney at Marval and Mairal in Buenos Aires. I'm a privacy professional certificate attorney from IAPP, and I generally advise clients on privacy and cybersecurity. Thank you again for this invitation to be part of this panel.
Great. I switch for Paulina, please, to introduce herself. And
yes, hi, thank you. My name is Paulina Bardon, and I am a senior lawyer counsel in a law firm Claro. I've been working in the areas of intellectual property, data protection, and consumer issues for about 30 years. And I am very pleased to be here, and I'm willing to talk with you.
Great. And Sofia, can you please introduce yourself?
Of course. Hi, everyone. Well, my name is Sofia Anza. I live in Montevideo. I work here in Regules. I have been working in relation to privacy matters for at least 10 years. And I want to share some news that we have here in Uruguay in relation to certain new regulations. And well, I'm very pleased to be with you.
Great. And then the idea of this panel, maybe we can start presenting if it's possible. The idea is to have the same topic discussed with different perspectives from different jurisdictions. And we are going to be pleased to answer any questions you have that you can do in the chat that you can start sending during our presentation. And then we can put all of them together and try to answer at the end of the panel. And we are going to start with Argentina. We try to all the time follow the same path: Argentina, Brazil, Chile, and Uruguay. And therefore, Mariano, you can start the show, please.
Thank you, Tatiana. Well, let me start with saying that in Argentina, personal data protection is governed by the Argentine Federal Constitution. The Constitution has several regulations on privacy, and in the amendment of year 1994, it included a specific provision on habeas data. That is an action, a judicial remedy that any person may file before courts in order to obtain the access or the removal or update to the information, to personal information. After that, 6 years after that, the Argentine Congress, approved a specific data protection law, a very comprehensive regulation in year 2000, and this law was inspired on the EU directive on personal data protection and the former data protection law, Spanish data protection law called LORDAT, that was after in year 1999 modified by another, amended and derogated by another law. So our system is basically inspired on the European regulations. It's very similar to the EU directive, not to the GDPR, but to the EU directive. So many provisions that you will find on the personal data protection law are just very similar to the EU directive. After that, 1 year after the enactment of the law, the executive branch approved the regulatory decree amending or supplementing specific provisions of the data protection law. And this specific regulation, the regulatory decree, created a supervisory authority that was called the Argentine Directorate of Personal Data Protection and was replaced by the Argentine Agency of Access to Public Information 2 years ago. This DPA has the authority, the task specifically to approve regulations on personal data protection. And in that sense, they have approved several regulations, several provisions complementing the Argentine personal data protection law. Let me say that Argentina has adhered to the Convention for the Protection of Individuals called the Convention 108 in year 2018, and also it was declared as an adequate country by the European Commission in year 2003. This adequacy decision, we expect that this adequacy decision will be subject to review by the EU authorities this year. We don't know in the current context where this revision will take place or not, but ideally it was supposed to take place this year. As to security and cybersecurity and security measures, I should say that particularly the Argentine personal data protection law has a specific provision on security measures. This is the Article 9, which imposes an obligation to data controller to implement the relevant security measures. It's a general principle. The law does not provide any kind of guidance or any measure that should be included. It's technologically neutral, but we do have a specific regulation. This is called the Resolution 47 of 2018, which approved a set of guidelines of recommended security measures, specifically addressing, for instance, the collection of the data, the backup and recovery of information, the development environment, the security incidents, and other technical issues. This resolution that is imposed, it doesn't impose, recommends some kind of measures that any company should implement, repeal a previous resolution that is very well known, that was the Resolution 11, 2006, that specifically addresses security measures, but the approach was different because the security measures that was imposed by the previous resolution was mandatory. According to the new resolution, this is just a recommendation. This is just a broad description of the Argentine environment here in Argentina.
Thank you, Mariano. Did you finish or can I?
Yes, you can continue with Brazil.
Thank you. Just giving you an overview about Brazil. Right now, our privacy law is not enforceable yet. The law is going to be in effect in August this year. If nothing happened, and then I explain later on, we have right now current different provisions in different law that in some way or the other rules privacy aspects, but we do not have a general law covering privacy. This is the one that we're expecting to be in effect in August this year. We have recently Since last year, a couple of bills of law trying to delay the enforceability of the law, but we have a recent one that is already approved by the Senate, and we are now waiting and seeing if the law is going to be confirmed to be delayed to January next year or not. We are in the middle of a situation that we really don't know if the August date is going to be kept or if we're going to postpone the law for January next year. If the project, the bill of law is accepted, the law is going to be enforced in January, and the sanctions of the law is going to be enforced just in August next year. But we have to follow up that and see what's going to happen. Our law also, it's very similar with the GDPR, of course, with some peculiarities and difference, but follows the same idea of the GDPR. What we are seeing in Brazil is a lot of companies really are getting adapted and implementing the proceeds and works to be in compliance with the law. We are creating in Brazil the privacy culture as well. Of course, Brazil is a big country with a lot of difference in regions and type of companies and size, but we have a strong group of companies that is already implementing that. But we have a long way and a lot of work to do in terms of privacy education in Brazil. And events like these ones, of course, it's very helpful for Brazil. We have as one very important aspect of the law, the security aspect, which is mandatory in terms of the controller should follow security procedures. There is a lot of provisions in the law that touch the security aspects, and then of course any implementation process that we are running to the law in Brazil, we have to look about all the legal aspects, but also it's important to analyze the security and control aspects of the law. And this is a key part, is the combination about legal, but also cybersecurity and security aspects with the law. We have the DPO, as we are going to talk a little bit late as well, and the needs also to inform security incidents that's going to be touched upon later on. But I think the most important aspect now is Brazil is facing and passing through a privacy education right now with different levels, of course, of expertise and expectation, but we are going there. We are right now in the position that we do not know when the law is going to be enforced, and most important, we do not have yet the Brazilian National Data Authority. This is a really very important issue because the authorities are supposed to provide guidelines, are supposed to provide additional regulation on the implementation of the law. And right now, even though it was approved to have the authority in Brazil, the authority is not working, is not in place yet. We do not have the members, the experts appointed yet to form this authority. And all the communities trying to and pushing to have that as soon as possible. Even if the law is postponed to January, it's important to have the authority right away to help and guideline the companies, the experts, and everyone involved in privacy of how the law is going to be implemented, and different aspects and articles of the law requires to have a specific implementation, specific information, and we are looking for that. But this is just a brief overview about what's happening in Brazil. It's important to watch out, and I will pass to Paulina to talk about Chile, please.
Okay, thanks, Tatiana. Unfortunately, Chile is one of the most backward Latin American countries in privacy issues. We have a privacy law that regulates the treatment of personal data that was enacted in 1999 before the internet became massive. Our privacy law is very difficult for those who feel affected in their privacy rights, since an ordinary action has to be filed before ordinary courts to claim any privacy breach, and the penalties are actually very low. So we see only a small amount of court actions based on this law. And most of the actions that we see and handle in courts are actions based on the constitutional right of personal data protection. That is a constitutional right that was introduced in our constitution a couple of years ago, on 2018. On 2017, the Chilean government filed a bill of law before the Congress, which significantly amends the Data Protection Act. This bill seeks, among other things, to increase protection of privacy in order to fulfill international standards in matters of personal data processing, and actually to meet most of the guidelines of GDPR, to adapt and modernize our national legislation to meet the challenges of a digital economy. This bill of law is very balanced and balances the safeguarding of people's privacy with the free circulation of information. The bill has not been approved yet, but we hope it will be approved soon. But it is in an advanced stage and expected to be enacted during this year, actually. Our DPA in a minute. Personal data may only be processed in 3 cases: when data subject consents, when law authorizes it, or when personal data come from a public source. The bill actually includes and other sources of legitimation in the process of personal data, as, for example, a contract between the parties or the necessary compliance with legal obligations, the legitimate interest of the data controller in processing the data, and when it's necessary to protect the life or health of the data subject. We have been, these days of the COVID-19, we have been talking a lot about this basis of legitimate processing, about how to protect the health of the data subject. We do not have, with our current law, data protection agency or any authority. So, as I told you, any action has to be brought to ordinary courts. It's expensive, very time-consuming, and the results are quite uncertain. The fines are also very low. You can seek for damages, but again, the chances of success are uncertain. In terms of security issues, our cybersecurity legislation is also very poor. And in the Data Protection Act, we just have the obligation of security, but not with the specific security requirements. And as I will talk later, some other public organizations has been approving and issuing some regulations on cybersecurity, most from the financial area. I will talk to that later.
Thank you. Thank you. Jump quickly to Sofia to tell us about her experience in Uruguay.
Okay. Well, here in Uruguay, from 2008, we have a law that established the legal framework in relation to data protection matters. This is a right, of course, as Mariano mentioned, here in Uruguay is the same. It's a right that was recognized by our constitution. The mentioned law and its regulatory decree are highly inspired in European regulation. In a nutshell, the mentioned regulation includes certain principles that I will summarize the most relevant. The principle of legality, according to which all databases shall be properly registered and shall observe the principles provided by applicable regulations. Other principle is the principle of purpose, under which the personal data may not be used for other purpose than those that motivated its collection. Further, the principle of prior and informed consent, according to which the treatment and processing of personal data must be preceded by the person's free, prior, express, and informed consent, which must be documented. Anyhow, there are some exceptions to this principle. In other principle, the principle of security, according to which all steps necessary to guarantee the security and confidentiality of personal data must be taken. Well, based on this framework, in 2012, Uruguay has been considered by the European Union as an adequate country from a data protection perspective, And in 2013, Uruguay has ratified Convention 108 of the Council of Europe. Further, and some after the GDPR were passed, Uruguay included certain modifications to the mentioned data protection regulations. This change had been included through a budgetary law and as from a decree, and the idea of these changes is to maintain the adequate category and be fully aligned with GDPR principles. The main changes that include those regulations that I mentioned implies the modification of the territorial scope of the data protection legal framework. Also, certain regulations related to security measures and cybersecurity measures are included. Additional regulations in relation to data breach are also included, and the figure of the DPO. I will talk later on in relation to the figure of the DPO and in relation to data breaches, so I will make some comments in relation to security measures and the territorial scope of our law. Currently, the processing of personal data is covered by our legal framework when it's carried out by controllers or data processor established in Uruguay. Further, and if the controllers of the processor are not established in Uruguay, our regulations are applicable if the processing is related to the supply of goods or services to inhabitants of Uruguay, or if the data processing is related to the analysis of the behavior of inhabitants of Uruguay. This includes, of course, the elaboration of profiles. In relation to security measures and cybersecurity, I want to point out that the controller or the processor must take technical and organizational measures to maintain the integrity, confidentiality, and availability of the information in order to ensure the security of personal data at all times. In this sense, the decree implements the concept of privacy by design and privacy by defect. Further, our regulation also includes the principle of proactive responsibility, which basically implies that the data controller or the data processor shall assume a proactive role in view of the nature of the data, the processing carried out, and the risk involved. To this end, all necessary measures must be taken, documented, reviewed, and evaluated in terms of effectiveness. Moreover, in certain cases, such as when sensitive data are used as core business or when large volume of data are treated, it is necessary also to carry out a personal data protection impact assessment. Well, moreover, I want to say that in order to control all these regulations, here in Uruguay, we have since 2009 a personal data protection regulatory and control unit, which is in charge of controlling compliance with applicable regulations and had wide inspection and sanctioning powers. Well, that's all from my side in relation to this matter.
Thank you, Sofia. Going back to Argentina, and we are trying here to speed up a little bit our speech. Mariano, can you explain a little bit how is the procedure of report proceeds in Argentina, how it works? Can you please go on?
Yes, thank you. Well, you know, here in Argentina, our data protection law is very old, as I mentioned. It has this year 20 years. This is the anniversary, and the law does not include any specific provision obligating or imposing the duty of reporting data breaches to the DPA, I mean to the Data Protection Authority or any kind of authority, or even to data subjects. But we have here, as I mentioned before, the Resolution 47 of 2008 on security measures as an additional recommendation, such as companies to report a security incident to the DPA, providing a copy of the relevant data breach report. This report shall contain specific information. It's quite similar to the GDPR as to the content that this report should include. And basically, it's the nature of the breach, the categories of the data, of the affected personal data, the data subject compromised or affected, the mitigation measures, remediation actions, basically the same. But it's just this, this resolution does not provide any guidance on the detail of information that a data controller must provide to the data protection authorities as to the incident itself. Basically, we don't have here any kind of guidelines or regulation, as for instance in Europe, which just give information about the content that the report should include when you are notifying an incident. Moreover, we have here the general principle of the common law of the civil and commercial code that basically could give some kind of position or give us more an idea of there is a need of reporting a data incident to the affected individuals when this can produce any kind of harm or damage to the individual, basically. In that sense, in the civil and commercial code, we have a provision saying that the company or any individual must take the necessary measures to prevent a damage, and also the good faith in the relation between parties. And when they have an agreement or a contract between the parties, this principle of good faith should prevail, and as a consequence of that, it could be understood that reporting a data breach between parties should be a good practice in that sense. And finally, let me say that we have here in Argentina specific regulations, sectorial regulations concerning privacy and data protection, and in the scope of reporting a data breach, we have the Argentine Central Bank, which issued a resolution last year, required financial institution. It is only for financial institution to report to the central bank any security incident that can produce any harm to the consumers or the parties that have any kind of relation with the central bank. And the last comment will be on a bill that was filed on March this year, which basically amends the data protection law. This was introduced in Congress, as I mentioned, in March, and it covers a specific. It includes a specific provision on reporting a security incident. We don't know whether this bill will be analyzed and discussed in Parliament, but I think it is important to make the comment on that. Having said that, I pass to Tatiana.
Okay, thank you for that. Well, in Brazil, we are still waiting. We do not have also guidelines or anything, as I mentioned before. Our authority is not in place and working and providing directions. There are a couple of moments on the law, especially in incidents that there is a reference that in some situations should have additional information. But thinking about incidents, our law requests to be reported by the controllers when the incident, the security incident or data breach will have relevant risk or damage to the data subject. It's not defined in the law what is considered relevant risk, and therefore we should have a broader interpretation. Maybe we can think about economic impact, we can think about moral impact, we can think about different type of impacts. There is a lot of subjectivity on the criteria for how we can define the relevant damage for a data subject. And should we also consider relevant data for the society, for others, how we are going to treat and to narrow the scope of relevant risk. These are important and a key point to be analyzed in the law, and we are going to see that later on case by case, on when we have a better interpretation of the law, and also help and assistance for the data security. Another important aspect is we have to do, as Paulina also mentioned, I'm sorry, Sofia also mentioned, that to run a good risk assessment, because with a good risk assessment, we can really be prepared for the incidents, for the data breach, and trying to minimize as much as possible, and to know exactly what needs to be done, how the impact, and what the company, the organization should follow. And then the risk assessment is a key part to definition of what is going to be the criteria, what's going to be done by the companies, and also good risk management, because the risk assessment is something that should be reviewed time by time. It's not something that you do in one moment and then forget that. You have really to create a continue working to do the risk assessment and manage that. And the manage of the risk assessment will allow you to revisit the case, to revisit the situation, analyze what's happening right now, and also with what's happening abroad. And this is an important point on cybersecurity, is the risk assessment and the management of this risk assessment. And again, we do not have a specification of how we can consider the relevant risk. This we have to analyze later on case by case, because also have to consider what type of data we are talking about, what really happened, who are the people involved on that. All these situations will be considered for the risk assessment, and also for the consequence, and maybe the analysis of what's going to be considered relevant risk. Finish on that, I'm going to ask Paulina to tell us a little bit about Chile.
Yes, yes. As I told you before, our law does not have provisions in regard with the reporting of security incidents. And in the absence of law, actually other authorities have started to react to privacy issues. This is the case of the National Consumer Bureau, CERNAC, on consumers protection, and the Commission for the Financial Market in regulations on cybersecurity issues regarding institutions under their surveillance. In the case of the Consumer Protection Act, we find provisions on the security of websites or apps. The website or app must have technical features to provide security and confidentiality. These security measures are related mainly to the redirection to secure sites and the cryptographic protocol, and the verification of the padlock symbol in the web browser without confusing security images, among others. Both the website and the apps and the means of payment offer must have a high standard of computer security, and the user should be informed about this. The Consumer Protection Act is very clear in this regard, and the CERNAC, that is the institution, is very active in sending reports to enterprises that have e-commerce and are active in the internet. And the Consumer Protection Act also includes a voluntary procedure for the protection of collective interest and subsequent class action lawsuit in the case of security breaches. CERNAC these days is actively seeking consumers' compensation in cases of consumers that have been affected by security breaches, such as disclosure of personal information, interruption of computer services, among others. This proceeding can be initiated by CERNAC or through a complaint for any consumer association. On the other side, we have the Commission for the Financial Market, that has issued several regulations for the institutions that are under the surveillance of this commission. They have the obligation, the obligation for banks and financial institutions to report cybersecurity incidents to the commission, including a 30-minute term to report the first information about any incident. They also have the handling of cybersecurity incidents by banks or financial institutions is considered a relevant factor to determine their evaluation and classification of financial institutions of higher or lesser rank. Regarding operational risk, regulations also require banks a permanent monitoring of operational risks, investment in technology, and security that shall mitigate this risk. They also have some regulations very specific on payment of credit cards, and also regarding the duties on the security duties regarding outsourcing of services. This is what.
Thank you, Paulina. I don't know, Sofia, are you in? We cannot see you. I'm not sure if you're there.
Yes, I'm here. I can see you.
Great. Sofia,
yes?
Can you explain a little bit about what's happening in Uruguay, please?
Yes, of course. Well, here in Uruguay, we have specific regulations in relation to security incidents. In fact, our regulations provide that in the event of a security incident, which results, among other things, the accidental or unlawful disclosure, destruction, loss, or alteration of personal data, or the unauthorized communication or access of such data, the person responsible for that or in charge of the processing must comply with certain requirements. And our regulations state that the data processor or data controller, as applicable, must start an impact mitigation procedure within the first 24 hours after the breach was discovered. In addition, the controllers are also required to report the breach to the Uruguayan Data Protection Authority within 72 hours. The mentioned communication to the Data Protection Authority must contain relevant information, such as the date or estimate date of the occurrence of the data breach, the nature of the data breach, a description of the affected personal data, and the possible impacts generated. Moreover, the controller must also communicate the data breach to the data subject who has suffered a significant impact on their rights. Here is similar to what happens in Brazil, as Tatiana mentioned. We don't have a definition of what significant impact means, so we have to discuss case by case. In relation to the communication to the data subject, there is not a specific a time established here. However, our regulations state that data breach must be notified to individuals once the data controller becomes aware of that. So we believe that the communication must be done as soon as possible. And finally, once the breach is solved, our regulations state that the data controller must elaborate a report setting for the measures that were implemented and inform that to the Uruguayan Data Protection Authority. Well, this is the procedure that we have here in Uruguay.
Thank you very much. Before we jump for another subject, we are trying to answer two of the questions that were already did. The first one's to Paulina regarding whether there is this situation in Chile in terms of privacy, whether or not this could have a cultural component as well. Paulina, can you also give us a little bit of your analysis on that, please?
Sorry, if the situation has a cultural issue?
If the break view of data privacy in Chile, as someone who tracked Chilean news and a former student there, this was a question for the person. I'm shocked that the data privacy is not more protected. I wonder if there is a cultural component. From his interpretation, the data privacy is not so protected. He would like to check whether there is a cultural component or what are the reasons for that. What's your thoughts on that?
Right. I'm not sure it's about a cultural thing, probably, but I don't think about Chilean people as being like very open about their privacy. I think we have this outdated law, and probably the authorities have not been active enough and proactive to enact a new law. But I don't think we have the idea of the importance of privacy until we face the internet issues that became so important in the last years. Probably it was the right to privacy was not considered a very one of the most important constitutional guarantees, actually. But I'm not sure if it is a cultural thing or just, I'm not sure really. I don't think so.
Okay. Well, we are talking about a little bit of DPO. Mariano, if you can just comment highly how what's happening, the DPO role in Argentina, and then we can just add additional comments in each of the countries if there is any difference, please.
Well, yes, thank you, Tatiana. As I mentioned, the data protection law is very old. So at the time of sanctioning this law, it was not considering the need of requesting companies or even the state as data controller to appoint a data protection officer. So you will find no provision on this specific aspect on the law. Having said that, we find a specific regulation of the DPA recommending the public authorities, this is just for the public sector, not for private sector, to appoint a DPO when processing personal data. Basically, is that we had a very important data protection bill that was introduced by the former president of Argentina in year 2018. In this bill was quite inspired on the GDPR. It was 95% similar to the GDPR, and it was the result of discussions with different stakeholders. We have the opportunity to participate in that project, in that bill. But unfortunately, this bill was not considered by the parliament last year, so it lost the parliamentary status this year and will not be considered unless it will be introduced again by any interest party. So to wrap up, we don't have this DPO, the DPO in the Argentine regulation for the time being.
Thank you. Just adding some of the what's happening in Brazil in terms of DPO. Of course, we have similar provisions with the GDPR. One important aspect that the DPO in Brazil could be an entity or an individual. It's not necessary to be someone from the organization. Could be someone out of the organization, and could be also an entity, not just an individual. And of course, it's important to highlight and to inform exactly who was the contact person, and this person should be also, of course, available, and it's the main contact between the data subject, the organization, and the data authority. And we are seeing in Brazil the people getting prepared to be a DPO, and the companies are organizing for that as well. There is a lot of them that decides to have a department or someone internally in the company running this deal, and then we have also to consider compliance aspects and the roles that the DPO will do in front of other activities or interesting of the company. This is an important aspect that should be considered as well. I don't know if Paulina and Sofia would like to also add some things. Paulina, please.
Of course, we do not, our law does not require to appoint a DPO. The bill do have the figure of DPO that can voluntarily be appointed by the data controller. It's not mandatory, as part of an infringement prevention model that is also voluntary. That's for Chile. I don't know, Uruguay?
Yes. Well, here in Uruguay, we have regulations in relation to the DPO. As I mentioned before, last year we have a new law and a new decree that established certain modifications to our data protection legal framework in order to be more aligned with the GDPR. So yes, now we have the figure of the DPO. And according to our regulations, all public entities from one side and private entities from the other, which treat sensible data as a main business, or the ones that treat big volume of data, which implies the processing of personal data of more than 35,000 people, must appoint a DPO. The role of the DPO here implies to be the link between the entity and the Uruguayan Data Protection Authority. Further, the DPO will have to advise on the design and application of personal data protection policies, oversee compliance with applicable regulations, and propose all the measures to adapt them to the regulation and standards on the matter. Regarding the requirements to be a DPO, here the DPO must have knowledge in relation to law and must be specialized in the field of personal data. However, we don't have information about what these specializations means. So probably this will be further discussed by the Uruguayan Data Protection Authority, and we will have more guidance later on. As Tatiana mentioned, here in Uruguay, the DPO can be an individual or a legal entity also. And in case a legal entity is appointed as a DPO, the organization must identify before the Uruguayan Data Protection Authority the individuals that will conduct the DPO activities. Our regulation also provides for the possibility of appointing a single DPO for a group of entities that have similar activities. And as I mentioned, this is a new requirement. So the entities still have a term to submit this information until the end of May.
Okay, well,
that is all.
Thank you. I think we are running out of time. We are on time, and I'd like to finish this panel here. Thank you, my speakers, Mariano, Paulina, and Sofia, to join me with this panel. As you all participants can see, there is a lot of similarities in law, but of course there is some difference as well. And depending of the structure of your organization, it's important to have to build a program that will cover different jurisdictions with different aspects, and this is something that could be done in a coordinated way and in a very way as well. We also thank you the opportunity from Saga University to be invited for this panel and to contribute, and we hope that you enjoy, and probably you're going to receive the presentation later on. Thank you very much for that. Thank you.